Tell him Dan Roach says hi. Tell him Dan Roach says hi too.
Wait, that was the story. He doesn't like his own hands.
So he can complain about everyone else's drawings, experts, but his drawings,
Just go.
it's fine. Yeah.
Welcome everyone to the regular meeting of the City of Annapolis Board of Appeals, March 3rd, 2020, the Super Tuesday edition. I'll ask our recorder to call the roll.
Mr. Gallagher,
I'm here.
Dr. Chen, present. Mr. Walsh,
Present.
Mr. Burnett,
Present.
Mr. Zazali.
It seems we have a quorum, so we'll go ahead with our business for the night. Tammy reminds me that the proceedings tonight are being video recorded. So for those of you with a speaking part, make sure your microphone's on. For the rest of you, good side to the camera. Have members of the board had a chance to review the agenda for this evening?
Yes.
Any changes or suggestions?
No.
I'm going to offer one change of my own. Typically, we have deliberations on all the matters before us at the end. Tonight, I'd like to exercise my prerogative to change that. We're first going to hear the motion to reconsider, and we'll deliberate that and decide in order that we can release our counsel for that matter and install our counsel for the next matter. Folks, we have a new person sitting up here tonight, newly appointed member of the board, Rob Dews, who as soon as he's sworn in the near future will become our alternate member of the board. So welcome, Rob. So tonight we have two items on the agenda, one piece of old business.
Mr. Chairman, I move that we approve the agenda with
good.
the
Second?
with the
Second.
addition that you with the revision you made.
Thank you. All in favor?
Aye.
All right, agenda is approved. And the second piece is an application by the city for a special exception. The appeal is appeal number 18002. This is an appeal from the issuance by the Director of the Department of Planning and Zoning of a certificate of adequate public facilities for the project known as the Lofts at Eastport Landing. The board has rendered a decision and order in the case vacating the certificate of adequacy because of certain facilities were demonstrated to be inadequate. The applicants seek reconsideration of the board's decision, and the appellants essentially cross-appeal, asserting that certain additional facilities are inadequate. So we'll turn to that matter now. Before we get to the arguments, the council, does anyone know of anything that we need to take up before we actually get to the arguments? Are there any preliminary matters? I can't think of any. No? Good. I think we're good. So, Mr. Hyatt, you have the floor. Can we try for 15 minutes?
I'll do my best.
Okay.
I mean, this certainly doesn't have to be the prolonged type of hearing that we have become accustomed to in this subject matter, but I do want to hit my points if I could.
Keep in mind, as always, we have read your
Right.
extensive briefs. And
Okay. All right. Just a little housekeeping matter. I have offered the affidavit of notification and posting into the record because it's our obligation to post the property and to send notice to the property owners within the vicinity as required in the code. So I've given that to the clerk.
Any objection, Mr. Rogers?
I'm not sure I understand that exhibit.
His affidavit showing notice, compliance with the notice requirements for the hearing tonight?
Yes, I accept it. He gave me a copy.
Okay. That'll be admitted then. Mr. Hyatt?
All right, thank you. On behalf of the applicant, which you know as Eastport Plaza LLC, Solstice Partners LLC, and SPRE Eastport LLC, we filed this motion for reconsideration. And that was filed within 10 days of the verbal decision because the rules aren't entirely clear. We have to file, so we filed within the 10 days. We were given the opportunity to file a supplemental pleading, which we did. So you have the motion and our supplement. What's interesting here is that standards were understood not to have been published. The fact is that there are standards on the city website. You know, the board was not aware of it. The applicant was not aware of it. We discussed whether there were standards. It just never came up throughout the whole process. So in the board's decision, there was a statement that none of the departments had published these supplemental standards, but in fact they were published. So that's significant. And interestingly, the department heads may not have been aware, but certainly their respective staffs were aware because they did a lot of work in support of these applications. Now, I'd like to take a couple of minutes to start and just review the applicable code sections, because we've talked about code sections and what they say and what they don't say, and it's important to quickly run through these because there's a section 21.30.020B that governs the appeals. And this board either affirms or reverses or may modify the decision. The board has all the powers of the officer from whom the appeal is taken. And the appeal was taken from the Director of Planning and Zoning. So this board stands in the shoes of the director. Chapter 22 spells out what the director does for adequacy of public facilities. 220810 starts off by saying the department administers the application process, and each department shall promulgate and publish on the city website the standards the department uses for certification purposes. And how did we discover that there were standards? Well, one smart young attorney in my office Googled City of Annapolis response times. And that got us to the link to planning and zoning, then to police, then home, then government, then Department of Planning and Zoning, getting started, and then ultimately to APF. So there it was all this time on the website. So each department is charged with the obligation to publish these standards, and that was done. That took place. The applicant is obligated to provide the Department of Planning and Zoning under 2208.020 information that the department reasonably requires. And then the Department of Planning and Zoning refers to each director or department that's responsible for the decision, for the recommendation. So you go to 2208.040B, and it says this: if all departments have certified adequacy or adequacy subject to mitigation, then the Director of Planning and Zoning shall issue a certificate of adequacy of public facilities. If one or more departments have found inadequacy, then no certificate is issued. What we had here is each department certified that adequacy was met, and the director in turn issued the certificate. 2210.010 describes what the departments have to do in terms of taking into consideration certain matters, and then 020 explains that each director or department makes this evaluation and then makes a recommendation. The specific review criteria are enumerated after that. You know, those are the 9 criteria that you heard ad nauseum over 6 nights of public hearing. And then under 2226.010, there's once again an approval. If there's adequacy or adequacy with mitigation, it's a directive. the director shall approve the application. Under 22-28-010, that's the mitigation section. If a project is subject to denial, an applicant is given an opportunity to mitigate. And this is where I think there was some concern that the board raised about the definitions. The level of mitigation under 22-28-010B shall be roughly proportionate to the projected impact of the proposed project upon the facility or facilities, and shall be determined by the Director of Planning and Zoning. So it's an evaluation that the director makes as to whether there is a significant impact or not a significant impact. And then the mitigation language states that a mitigation consists of the construction or funding of improvements to on-site or off-site public facilities by an applicant so that the capacity or safety of the facility after mitigation will be equal to or greater than if the proposed project had not been developed. In other words, it's not making it worse. And I know there was some umbrage taken by the board when there was some testimony about this, but that's what the code says. You know, the idea is you want to put it back to where it was before you initiate your project. And if you have a problem, if there's a failing intersection, you can't make it worse, is what this says. Now, what we did is we presented all of the departments to testify about the 9 criteria. You found that 4 were satisfied, not knowing that there were actual standards published. The 5 that you found fault with are as follows. 1 was police services. And at the June 4th hearing, Sergeant Miguez testified that she added the number of units from the lofts at Eastport, it's 98, and added that to the city's population based on a 2010 census. She concluded that 122 plus a fraction officers were required, and there were 124 budgeted. She determined the response times were adequate, and that the proper calculation is the numerator is the number of police officers in the city budget divided by the number of residents, which is also divided by 1,000, and that number has to be greater than or equal to 3.2. The board decided that the department's determination was unsupported by the evidence, but this is a pretty objective type of a standard. If you look at the calculation of population on our Exhibit L that was submitted, there was a third party that did the calculation of population growth. It determined the population to be 39,751. If you add the 98 residents and you even multiply that by 2.38, because that's the average of the household size, you end up with a population of 40,028. So that's 40.028. You multiply that by 3.2, that takes you to 128 officers. The city's budget, which I'm going to hand out a portion of when I conclude here, says there's 135 officers in the budget. So it satisfies that requirement. And I think there's very little subjectivity in that test. There's either officers that are budgeted or they're not. And if they're not, we have the right to mitigate. And I don't know, we didn't have to mitigate because there was a determination made that we satisfied the requirements. But what would you do to mitigate? I don't know. Have a guard there during the evening? I'm not sure. That's a discussion that we didn't have to have because there is adequate police protection under the code and under the budget. So, I mentioned in the motion and the supplement that I don't think the remedy to remand is appropriate because you stand in the shoes of the director. But if you need more information, in fairness, if you stand in the shoes of the director, I think you can ask for more information. If you're not satisfied with what I'm giving you, you could always ask the police department to provide the information to verify this, but you have standards spelled out on the website. You have the police department satisfying those standards. You had the testimony, you had the writing, and I think everything was done that had to be done to show you and to show the Director of Planning and Zoning that police was adequate under 22.14. And I don't want to be redundant because I'm limited on time, but again, 2208-040B, if the department certifies that the project can be served by adequate public facilities, the director shall issue the certificate, and that's what happened. So when there's an appeal, you know, it's tough to appeal an APF certification. First of all, I think this is the very first one that's ever taken place. It's a much different appeal when you get into site design and all that subjectivity, but here we have objectivity, and I just don't see how the board could reject that there was adequacy of police protection. The next one that is somewhat similar is recreation facilities under 22.20. This may be the most objective because the code says that you need 500 square feet of public recreation space for every apartment. You have 98 units, that takes you up to 49,000 square feet of recreation area. 41,494 square feet was provided. The memorandum from Mr. Trader, the chairman, says that, or the department head says 7,506 square feet are remaining. That's 500 square feet per unit. That's 15 units. The city council determines how much the fees are. This is not something that's done arbitrarily, and it's not done by each department. There's a resolution adopted every year by the city council. They determine what the fees are. So the standards were published, the fees determined, the methodology spelled out in those standards was carried out by the department, recreation department, and the conclusion was you need to cough up $3,750, and then you have recreation area for the rest. If the board disagrees, I think the answer is to get the code changed. I mean, you know, unless you say, well, we're not going to count this or we're not going to count that. If you're not going to count that, then you would just have to add to the fee. It's $250 per unit. I think that's what you're obligated to do. And then to challenge, you know, it says within a half mile. The interpretation is a radius, except the department says we're not going to cross the creek. You think maybe it ought to be done differently, but I don't think that's within the purview of the board. I think that's getting beyond what the board should be deciding. I think the board has to look to see if the department heads followed the standards and satisfied the requirements of the code. Moving on to traffic impact, 22.21, that section of the code requires a traffic impact analysis. That's what it says. It doesn't set the criteria. It doesn't set what the requirements are. Instead, there's a set of standards published, and it refers to the policies and guidelines for traffic impact analyses for proposed development in the city of Annapolis. That's what the Department of Planning and Zoning works with. They hire a traffic engineer paid for by the applicant. The scope is determined by the city, and they have guidelines. They don't have hard and fast rules. This was a topic of great debate here, but when the city determines that there's a problem at an intersection because it's at level of service E, and the traffic engineer in his study says, here's what you have to do to upgrade it. You have to optimize the signalization. That is what the Department of Planning and Zoning agreed would have to be done. And then an additional lane on Americana Drive. That's the directive from the department. The board may want better traffic flow. You might want a level of service B or A, but That's not a call that you make. You don't have that discretion. This is a situation where I again refer you to that mitigation section, and it's within the discretion of the Department of Planning and Zoning. That department evaluates an urban project and determines what's to be done and what's not to be done with regard to traffic. Those are policies and guidelines, not hard and fast codified sections. It was the traffic study that the City Department of Planning and Zoning relied upon, and it made the conclusion and directives as to what had to be done. I think you begin to second guess and get into areas that I don't think are appropriate for the board in this type of an appeal. Again, remember, it's APF. We get into non-auto transportation, chapter 22.22. The 14-foot widening strip came up again. The evidence, I think, is quite clear. There's a 14-foot widening strip. Part of Bay Ridge Avenue lies within that 14-foot widening strip. The 14-foot widening strip is not in any way, shape, or form part of the applicant's property. It was never counted. It did not become part of the project, and it's a red herring is what it is. The title to it may not have been transferred to the city. I can't help that, but the owners of the shopping center don't own it, and it's being used now for public purposes. It's just not counted as part of our property. And meanwhile, under non-auto transportation, the standards are published once again, and there's 4 factors. This isn't complicated. They have to be addressed. It's bicycle facilities, pedestrian facilities, transit facilities, and then there's this discussion about signalized intersections with appropriate appurtenances for bicycle, pedestrian, so on and so forth. That was the testimony of Dr. Nash, where she required the applicant to install bike lane, sharrow markings, and crosswalk markings, and that sort of thing. So you begin to substitute your judgment for that of the professionals, and they followed the standards. And in my motion, I stated, you may not like the standards, you may not like the code, but I don't think it's appropriate to start adjusting these things. It's just not anything that the code gives you the authority to do. And then finally, the stormwater management, chapter 22.24. Again, the standards are published. Our civil engineer said that this site is 92.5% impervious with 0 stormwater management practice on it today. He explained that while redevelopment requires 50% treatment, in fact, 74% of the stormwater is being treated. He testified that there are 8 micro-bioretention areas, a green roof, among other features. This exceeds the requirements by almost 25%. The fact that there's channelization out at an outfall, and there were photographs of that, really doesn't relate to the adequacy test. Yes, that may exist, and maybe this site is contributing to that. I imagine other sites are contributing to it, but now we're going to try to cure that. And something else to remember, which I think is very critical and may be overlooked, APF is not the stage where an application is being made for a permit. This is a preliminary situation. And when the application is made for a permit, that's when the department will roll up its collective sleeves and find out if the pipes fit or if they don't fit or where we have to install these things. This is adequacy, and the calculations work. They satisfy the standards, and if the standards are satisfied, I don't know how this board can overturn that. I think the applicant, certainly the appellant didn't meet its burden of proof. The applicant met its burden of proof early in the process. The appellant didn't meet its burden of proof going forward because it's just thrown something at every one of these criteria and it didn't overcome, the appellant didn't overcome the fact that the department heads issued their findings, and I don't disagree that those findings were a little light in their documentation. I don't think that violates the code, given the fact that you did get written certifications from all the department heads, coupled with the explanations from the department heads here and the expert witnesses, I think is more than adequate for you to recognize that the departments did their respective jobs. I don't think that they are required to give an in-depth written report to the director. It doesn't say that in the code. If they certify, then the director shall issue the APF certification. So in the appellant's response, they continue to make substantive arguments we've heard over many nights of testimony. I mean, I think we're done with that. You would like to see better standards. I get that. I think the Department of Planning and Zoning has heard that. I believe, and hopefully they'll communicate this to you, that they intend to supplement their standards, make them better, because maybe they were taken for granted. But the fact is that the departments had standards, they satisfied their standards, they did their jobs, and the APF certification should be affirmed, particularly in light of the standards being published. Now, I respect the fact that you sent it back for some further detailing. You know, if you absolutely feel you need more information, I think you're entitled to it, but I would ask that if you're going to do that, be specific about what it is you want, because standing in the shoes of the planning director doesn't allow you to request that policies and procedures be changed or standards be changed. I think you can make a recommendation and as I say, obtain a little bit more information. But overall, I think the board is compelled to approve the certification, and you know, I would urge you to do so. This certification didn't come lightly. There was a lot of work involved, and I would respectfully ask you to reconsider your decision, especially in light of the fact that the standards have been published. And with that, I would conclude. I would like to hand to you the portions of the city budget, so you have that. It's on record, it's a public record, but I'd like you to have it. And then I'll turn it over to the appellant.
I object. New information is not allowed by Rule 15.
Yeah, Mr. Hyatt, do you have a response to that?
Well, it's not new information. It's just it's like, you know, I can give you a section of the code. I can give you a section of the budget. You know, this is all on the record. I would just. Okay.
First of all, let me thank you for bringing to the board's attention the existence of the published supplemental standards. I looked for them and I couldn't find them, and counsel for the board couldn't find them either. And also for bringing to our attention the reference in the code to the fee schedule for the fee in lieu. We, notwithstanding appellant's objections, we of course will consider the supplemental standards that you've pointed out to us, because they are not really in the nature of evidence, but they're regulations in essence under the law. So we will consider those.
Thank you.
I don't see us turning this police ratio calculation into a moving target. We have the letter from the police department saying what they relied on and what the budget was then, and that whatever the new budget is, that I think that crosses the line from authority to evidence, so we'll decline to take that in the record. Any other members of the board have questions for Mr. Hyatt?
Mr. Hyatt, can the Director of Planning and Zoning reject a department head's certification of APF?
I think the code section would allow the director to ask for more information, but once there's been a certification from a department head, the Director of Planning and Zoning is obligated to accept it.
So, given a hypothetical scenario, let's say a director of a particular department certified based upon their specific criteria that it meets adequate public facilities, but there's a glaring mathematical calculation. Can the Director of Planning and Zoning look at that and say, I can clearly see there's a mathematical calculation error that even though you certified it as being adequate, can the director then go and reject that department head's certification?
You know, the code says when the departments certify adequacy, the director shall issue a certificate. But as a practical matter, if there's clearly a mistake, I would think that the director would have the inherent right to go back to the department head and say, hey, wait a minute, 2 and 2 isn't 5 here. I would think that would go
And
with that.
so then what about does the director have the ability to question the department head's certification as it relates to the methodology that they relied upon?
I think that's getting a little far afield because I think the code puts squarely in the hands of each department their area of expertise, and the Director of Planning and Zoning is obligated to rely upon each respective department.
Thank you.
Mr. Chairman, if I can follow up on that, Mr. Burnett's line of questioning. If I take your argument, and we've heard this phrase for months now, that this board stands in the shoes of the planning director, you say it in your brief, and you said it here tonight. Just a moment ago, you said that to the question Mr. Burnett asked about what happens if we, as standing in the shoes of the planning director, find that some of the determinations made by the department heads may have been lacking, that there may be a question of whether there is adequate public facilities based on whether they certified it or not. So, in essence, am I misconstruing what you're saying? But you're more or less saying this is the adequate, the certificate for adequate public facilities is more or less a pro forma process. All they have to do is produce certifications from each department head, and we sit here after now 28 hours of testimony and say, yep, they were certified, so let's just go with that. That's your argument.
You know, that's what the code says.
I'm well aware what the code says.
Yeah, and so I think that the fact that we went through all of this exercise because it's a de novo hearing. That's what also the code says. So,
Yes.
I don't think we can, I think we had to address each of the criteria, all 9. I think we had to address them. And it was a rehash of each of those 9. This is what each of those 9 criteria and respective departments, I mean, sometimes it was one department doing multiple criteria, but this is what they produced for the director. So we did a kind of a redo because it's de novo for the board. And I think that because each department certified, I don't know that there's a lot of discretion in the hands of the board.
So if following that same reasoning, again, maybe it's being redundant of Mr. Burnett's previous question. So what you're saying is basically that the planning director, too, once presented with a certificate from a department of that particular criteria, one of the 9 criteria, are satisfied and certified by the department head, then basically the planning director has no discretion but to simply rubber stamp it and move it along.
I don't think the director has a lot of discretion. At 2208-040B, if all applicable departments have certified that the proposed project can be served by adequate public facilities, the Director of Planning and Zoning shall issue a certificate of adequate public facilities to the applicant.
Can you just continue on from there, the next two sentences?
In that code
Yes, in
section,
that same
if the
section.
department finds that one or more of the departments have found inadequacy in the public facilities that would serve the proposed project, no certificate shall be issued, and the Director of Planning and Zoning shall notify the applicant in order that the applicant may proceed in accordance with the requirements of 22.28, which is the mitigation section.
Right.
So if the department say, sorry, it's not adequate, then that sends the director down another path. But if the department say it's adequate, then the director shall issue it.
So on the one hand, you acknowledge and quite rightly pointed out this is a de novo hearing that we went through.
Right.
On the other hand, you're saying that it's basically a de novo hearing to allow just another presentation of information that we can't really question, just simply rubber stamp, move along.
Well, if each department head says that they satisfy adequacy, this is what the code says. And I think this is a much different appeal than
A standard appeal.
site design, where you have subjective criteria. I mean, this is spelled out, and again, it's one of these things where you might find it distasteful, you might not like it, but this is what the code says, and I think we're all bound by the code.
Thank you.
Thank you.
Nadine?
So, Mr. Hyatt, you talk about a site design hearing being different from APF because it's more fuzzy, the criteria. So if I recall correctly, at least some of my concerns, which led to my opinion, was that in fact there was no fuzziness, but in fact criteria that did exist were not met. So I'm not really sure I'm following your argument, site versus APF.
Well, in APF, there are these 9 criteria, and the various departments have to weigh in on those criteria. If the department heads, the professionals, conclude that there is adequacy, then the director shall issue the certification. The board stands in the shoes of the director. That's stand in the shoes are my language, but that's what the code says. So if you have department heads that have standards, which, I found them after all that clicking, but that they are on the website. If the various departments followed their standards and determined there was adequacy, I'm not sure what discretion the director has, and in turn, what discretion the board has. I think there's a big difference. If you look at the criteria for site design plan, that talks about general welfare and impact on the community. It's a different criteria. This is different.
So you're saying under the code, this board would have the ability, stepping in the shoes of the director, to modify the decision that was made in a site design situation.
Right. That's
under the code.
Yes. Yeah. And you have to look at the criteria. It gives you a lot more leeway. Unlike APF, which is much more objective. I mean, look at the schools, for example. I mean, there's been a lot of banter about schools. They're either open or they're not open. There is not much discretion there. You can talk about population and all these things that the appellant raised, but it's not relevant. Same with police. You know, either there are enough police budgeted to meet the 3.2 criteria or not. And I believe recreation and parks is the same thing. Where I think we may disagree, or where you collectively may disagree, is that you don't like the idea that recreation and parks determine that within this radius there are certain parks, but you can't really get to them that easily, so maybe it's more than a half mile. You know, I don't know what to tell you there. Maybe get the code clarified, but that's a pretty objective criteria. It's like you can't miss on that. If you disagree, then you increase the amount of fee in lieu. But I think the board went a little bit beyond its charge, respectfully, in making the determination that it made in this case.
So I'm wondering why during the presentation of your case, you didn't make this position more strongly or at all, in fact. Also, this information that you're providing with us now was not given to us during the case.
Well, the information, I didn't know that the standards were, well, if I knew the standards were published, I would have raised my hand a long time ago. I did not know there were published standards. And I don't think anybody here, the department heads or the Department of Planning and Zoning, the director, I don't think they knew. I think
So
it was
it's not important then. The standards were not sufficiently important in the process for either the city or the applicant to address them during the 6 nights or however many nights we were here.
Interestingly, the standards were addressed in the testimony. In hindsight, at the time, nobody was addressing standards.
Yeah.
They were addressing what they thought was the
But they were
appropriate-
not addressed with any clarity.
Well,
It was not, go to website XYZ here
that was not
is
said.
evidence
No, that was not said.
submission.
And why did
So
I
it
put
seems like the standards just simply were not a consideration on the city's part or the applicant's part.
Right. We think the standards were met via the testimony. If you look at the standards.
But how can you know? You said you didn't know the standards. You hadn't read them. How could you know they were met?
I know.
Merely because the department had certified. You took that on face value, correct?
The department head certified, but surely their departments, the staff within their departments must have known about standards because.
Do you know that?
I don't know that. But how would they have determined? Well,
we can't take your word for that.
you can't. I'm not asking you to do that.
Well, so should we call them again? Which we can't?
Heaven
No,
forbid.
I'm being facetious. I'm being facetious.
Okay.
I'm making a point,
Yeah.
okay?
Well, if you look at the standards that are in fact published that we discovered after the fact, I don't want you to misunderstand what I'm saying. I didn't hide them.
No, I'm
Yeah.
not.
Yeah.
I'm in fact saying
Right.
the opposite.
I was, incredulous that, oh my word, there's standards after everybody said there's no standards. Well, here they are. Well, if you look at those standards and you match the standards to the testimony and the exhibits, they were addressed. So somebody somewhere followed those standards in these departments to make a determination. That's my point.
Okay.
All right?
All right, thank you, Mr. Hyatt. Thank you. Would Mr. Braithwaite like to be heard on behalf of the city?
Wait, Mr. Chairman, I didn't finish answering your question. Why did I bring all these people in? Well, this is the first appeal of an adequacy of public facilities certification. I thought the proper thing to do was a de novo hearing There's 9 criteria. Let's parade these people in front of the board and explain why it is they made the determination that this met adequacy. And then, we brought our experts in who put the plan together. That's why I did that.
There's enough embarrassment to go around for all of us for not finding the standards.
I'm not embarrassed. I mean, there's not clarity as to what we should or should not have done. So, thank you.
Mr. Braithwaite.
My name is Joel Braithwaite, and I'm with the Assistant City Attorney in the City of Annapolis. The City of Annapolis appreciates the consideration of the board in this matter. The city has been working diligently to comply with the board's opinion pending the motion for reconsideration hearing. To comply with the board's opinion and order, we have created a 3-step process. First, we revisit all the remanded APF sections and re-examine our determinations based on the board's decision. Second, we will revive and update our published standards and create report templates for each determination of adequate public facilities as required by the city code. Each decision will have 5 sections. Section 1 will be a determination of adequate public facility related to the applicable code section. Section 2 of all reports will include the purpose section, which is 22.02.010. Third, we will address the full adequate public facility code as applicable for the particular type of decision. Fourth, we will have the discussion of mitigation to the extent mitigation applies. And then we'll discuss the standards that we applied in deriving our decision. Any future or pending determinations will be issued in this format. The city anticipates completion of its internal review, revision process, and approval process, including any mitigation plans as required by the city code for if in the event that inadequate public facilities are determined. And we anticipate having our review complete by the end of this month. We will implement this approach regardless of how the board today rules on this motion for reconsideration. Next, after we have sealed this process, we will convene all stakeholders to discuss potential changes to Title 22. This includes the department directors, community members, developers, our city council members who are also very interested, and hopefully also the members of the board will have the opportunity to participate. While this is a longer time frame, we hope to have a draft ordinance review by the fall of 2020.
Thank you, Mr. Braithwaite. I think it's a very constructive response. I appreciate that. And I just want you all to know that I think the board has great confidence in the ability of the director and staff at Planning and Zoning to make these constructive changes. That's part of the reason why we decided to remand, because we want their expertise applied to these issues. So, thank you.
Is it possible to get a copy of his statements?
You can ask him, or you can get it off of the videotape if you like. All right, we turn to Mr. Rogers. Mr. Rogers, I'll also thank you for the extensive briefs that you've prepared on this, especially the one that shows the striking evolution in your legal writing style. And to make things equal, I think since Mr. Hyatt had about 22 minutes, we'll give you 22 minutes.
I'll try to
But
be
you
short.
don't need to take it all.
Thank you. I did submit a objection, an opposition, an encounter on
We read it all.
and I don't need to go through that in detail. But Mr. Hyatt has, the applicant has talked about this new information, which he's calling standards. And I will proffer that these standards are probably 20 years old. They're not applicable. And if you go to the police APF article, it talks about the year 2000 census. The year 2000 census is not what we're working with today. We're using the 2010 census. And the memo from the police chief, Scott Baker, contradicts Mr. Hyatt's statements, which you have noted. And we agree that there's conflicts and there should be at least 5 more officers. And I don't see how this all works together. The old adequate public facilities for police is, what would you call, an anachronism. It doesn't fit, it's out of date, and it doesn't make sense. And it doesn't use the right ratios. It doesn't refer to the comprehensive plan numbers. So, as I noted in my opposition, if there's one APF that fails, the whole thing has to fail. So there's no maybes, like Mr. Hyatt says, you shall do this or you shall do that. If one fails, they all fail. So if you go to the water and sewer facilities, Ms. Burkhart talked in her testimony that they use the AWWA, American Water Works Association standards. There are at least 9 American Water Works Association standards, substandards, that she talked about. She didn't talk about in detail, but in that detail, it talks about capacity, it talks about pressure, it talks about reserve, it talks about treatment. So the water system in Annapolis is made up of a number of key elements. It's the water plant, it's the wells, the water plants, pumps, distribution system. And when we noted that the fire marshal handed to the Public Works office the determination of adequate flow for Public Works, that got dropped. Ms. Burkhart says, I missed that. So that's totally unaddressed, and it's in the code. In this new thing that Mr. Hyatt has produced, it says that they shall determine an adequate flow which must be at least 2,000 gallons per minute. So I'm going to go into the grass now. The grass says they did a fire hydrant test. They tested one fire hydrant. They got 1,295 gallons per minute out of that one hydrant at 52 pounds per square inch. The tables show that if this has to be 2,000 gallons at 20 PSI, which is more than half, it's about 30% of the pressure. So if you have 30% of the pressure, I'll do a hypothetical question to you. If you have the pressure, are you going to end up with more water through the fire hydrant, or are you going to end up less water coming out of the fire hydrant if you have the pressure? My answer, you're not supposed to answer these. My answer is you'll get about half, but the way flows work, maybe 2/3. So you have one hydrant, which if you do it at spec pressure, you're ending up at 2/3 of 1,200 gallons per minute. But this new thing that Mr. Hyatt has handed us says you've got to flow 3 hydrants. You didn't do that. He didn't do that. He only flowed 1 hydrant. So I don't care which standard you use. If we go through every one of these in detail, the stormwater management, they're supposed to go 500 feet downstream from the effluent, from the bulkhead where the water comes out. They're supposed to go 500 feet downstream is their charge in this new standard. They only stopped at the bulkhead and said, that's not our problem. I delivered a drawing that got taken out of their set, which showed the stepped sediment trap or flow trap, and that got taken out. So they've completely, I don't care which standard you use, they don't make them. They don't meet the standard. We can go through every one of these if you'd like, but I think that's not the point. I proffer that they're inadmissible. They weren't talked about, like Dr. Chen says. They weren't offered in the court session, in the appeals session. And to argue the point that Mr. Hyatt is trying to put forward is that there weren't, the only people that provided findings, the department heads, I think was the recreation and the police provided the memo. The rest of them, there were no findings. The Public Works Office Director gave 3 sentences. And the 3 sentences were just approved. No findings. We don't know what model they used. If you go to AWWA, it says you've got to use a water hydraulic model. I asked that question. Nobody's run a hydraulic model. Does the city have a hydraulic model that they maintain? And when you add usage, you've got to check the capacity. You can't ignore the capacity. So if you go to the city, this is new information, so I can't give it to you, but it's the City of Annapolis Water Sewer System Evaluation Plan, 10-year plan. In there, I proffer that it says the system has serious problems in specific areas. They didn't tell you that. This should have been the Public Works Director's findings. He should have given this to you. He didn't. He didn't provide it. I went on the internet and found it, just like these other specs. But it says there's pipes that have to be replaced. There's pretty close to a $70 million backlog in replacement and some maintenance. They have 2 big projects scheduled. One is one of the tanks. And you know what? You look at the budget, they're stealing $1.5 million out of the water fees collected and giving it to the general fund. This is supposed to go towards fixing the pipes, not going into the general budget.
Mr. Chair, can I ask a
So,
question?
yeah,
Can I ask a question?
sure.
I'd like to ask a question, and not to get you off topic, but it looked like you were switching gears.
Well, you are getting me off topic. That's okay.
Because you said something in the beginning and then you sort of moved away from it. Can you address for me Mr. Hyatt's argument, basically that once there's been a certificate of adequate public facilities by a department, the director can't go behind and check the methodology because the code says
I was going
shall.
to get to that in the end, but you.
Well, I figured I'd like to do it now
asked
so that way we can address that and then get into the weeds of the details.
Guess what? People screw up, right? Have you ever made a mistake in your life?
Don't answer that.
You guys are, and ladies are here to be the adjudicator. If somebody screws up, you're here to filter, to catch it. And we've provided huge amount of graphics, copies of information, and dug deep into the standards. And we've shown that there are problems with the sewer system. It can't take the tributary area worth of sewage. If you just take the shopping center, it's great. It's just like the stormwater. They didn't calculate the tributary area right. TR 55 tells you how to do that. They didn't do that right. So when you take all these things they didn't do right, you have as in my brief, I've used the word indeterminate. Many of the questions that you and I and he has are indeterminate at this point in time because they didn't do testing. Now, some of these tests are in the standards, which they quoted, but not in detail, AWWA, okay? There's the MDE manual. They didn't do the overbank protection like they should have. They did. It says 170 feet downstream, and they said it's only 100, but the old standard says 500. So we have a problem here where people have screwed up. This is a chance to get it right.
Right.
We have the opportunity, and it's already started, Mr. Brathwaite. This is wonderful. One of the first conversations I had with Tom Smith when we started this process was, even if I don't win, and I'm not calling it a real win, because we all spent a lot of time on this, even if I don't win, we're changing what's wrong. And I told him that,
And to that,
at the
and to
very
that point,
beginning.
let me ask a question to that point. Let's say I agree with every single thing that you say, that everything that you've presented is 100% correct, and there's all these problems with the adequate public facilities. So let's say hypothetically I agree with you. Mr. Hyde is saying, too bad, this is now my words, too bad, because the code says if the directors of each individual departments issues a certificate that says it's adequate, tough luck, because the code says you shall certify as adequate public facilities. And I'm asking you to direct this board's attention to the law,
Or,
case law, code, whatever, that allows you to refute his argument that we don't have the ability to go back and check the methodology as to what each department head did.
The code says that you can stand in the shoes of the planning zone director, and you can approve or disapprove the certificate. You can deny it, you can recommend modifications, you can do whatever you want. Now, if the planning and zoning director has that same authority, that's not a question anymore. But hang on. I've done the research on the internet, and I'm not saying that's the law library, but I've done the word shall. The word shall is in every section of the APF. It says you shall test this way, or you shall make this kind of a discovery, okay? And then the shall is used again in the decision of the director. The law says today shall doesn't mean what it used to mean in contract law. It doesn't mean what it used to be. You can do anything you want with that word shall now, legally. And I'll provide you with that language if you want me to go research it again. Shall doesn't mean a thing anymore. And you can test it, you can put it in a contract, and it means nothing anymore. So I'm proffering that Mr. Hyatt's argument is nice, it looked like it works, but it doesn't work anymore in law.
And that's based on your contention that the word shall does not mean mandatory.
Shall is not mandatory anymore if you want to test it.
Got it?
So we go down this path.
I'm giving you 2 extra minutes for that.
Okay, well, he used up my time. It's his fault.
That's why I'm giving you 2 more minutes.
Thank you. Recreation, there was no real space provided. A walkway is not space. We can go back over that argument, but it's ridiculous. There's no recreational space. The police memo is in direct conflict with Mr. Hyatt's comments. The traffic study, I talked to the ITE main office today, and they agree it's fuzzy. And if we want to say a level of service is E is no good or D is no good, that's your option. They don't make that recommendation, they just tell you what it is. But level D and level E are, what would you say, are unacceptable for traffic flow, and they need to be dealt with. The widening strip, I still maintain that space, that 14 feet, has got to be in the drawing someplace. It's on the plat when they created the shopping center. It's not on their drawings. So someplace between Mr. Bernstein and Mr. Liederberg, that 14 feet has disappeared. That's why I called it the ghost 14 feet. And I contend to you, I've paid an attorney good money to do a search on it, and that deed exists, and it belongs to Mr. Liederberg's past company, Eastport Plaza Partners, LLC, but the partners has disappeared. It's no longer in existence, the best I can determine. So that property is going up for tax sale in April. No mitigation. Mr. Hyatt is talking about mitigation for a delayed project, but they haven't submitted a plan. What's the plan? The code says he's got to submit a plan if he wants it. So I suggest that if you are going to delay this or let it go on and linger, instead of just canceling and let him submit a new project, I proffer that a new project is the only way all this is going to be solved, and it complies with the new things that planning and zoning is coming up with. And that's the way to solve this whole thing. Stormwater management is totally inadequate. And last of all, the environmental approval. They have no environmental approval for this project. The MDE has said in a letter that they are waiting on the environmental new requirements from the applicant. The project is approved for commercial construction only. In order for this to go forward, they have to get residential approval to go with residential environmental standards. There's a whole list that's 10 to 100 times more stringent than the commercial contamination standards. So without approval from MD, the city of Annapolis has no planning and zoning environmental person. The environmental person would have been the person they would have asked to answer these questions. But the code says that if you don't have that, you have to go to your environmental expert. And the city's environmental expert is MDE. And just like the health officer for the city of Annapolis is the county health officer. And the schools person is the school person at the county, because they also work for the state. The city doesn't have every department that the code requires, but you have nothing from the environmental department, which is MDE, that approves this project for going forward. I'd like to touch base quickly on the 4 counter arguments. The schools.
You have 3.5 minutes.
Thank you. The schools issue, it has to do with the legislation, which Ross Arnett, our alderman, protested. And at the end of the article that they passed, it says, and in cases when you're at variance with the county, you have to go with the county. Well, there's also, I listed in my counter, the code section that says that you've got to use the EMPF, Educational Master Plan. They didn't do that. It's in your code. They didn't use that. And so quickly, there's no provision in the code for a partially passing APF. There was some discussion here by the board early on that says, well, maybe. The term maybe was used several times. There is no maybe. And like I said, this term shall in contract law has been eaten and destroyed in the law. So what you decide to use in place of the planning and zoning director is really up to you. The sewer flow, if everybody in Watergate and this new project and the surrounding houses flushes their toilet between 7:30 in the morning and 8:30 in the morning, there isn't enough capacity in that 8-inch pipe to take all the sewage. They didn't do a peak flow analysis, just like the water. You're supposed to do water analysis at peak flow period. You add the firefighting period, and they didn't do the tributary area. They didn't take the consumption from all the houses and Watergate all at the same time. That's what adequate public facilities is. You have to look at the public facility, not just the development.
You've
And
got
so-
a minute. You want to wrap it up in a minute?
And I'm not supposed to give this to you, but your planning and zoning department already has it. The storm drain and water management report for 106 and 108 Annapolis Street. They did the same thing in their stormwater management study in this project with Hammond and Wilson as they did in this project. They repeated the same mistakes. They didn't do the tributary area right. And so until we get this, you have the opportunity to set the city straight. Give them recommendations. But they're not doing this review correctly. They're not doing the standards. They're not going to TR 55 and forcing this thing through all the nooks and crannies of the standards.
Okay, we get your point.
Thank
Let's see if any of the board members have questions for you. I'm going to start with your side, Nadine.
Sure. Mr. Rogers, I think Mr. Burnett was trying to focus you on the legal issues that are at hand before the board at the moment. So I'd like you to address your legal argument that you made on page 8 of your brief that you provided to the board, which speaks to the principal party. If you could speak to that, please.
I brought this issue up in my appeal, and administrative appeals from the decision of an administrative officer in a government capacity, every other county and several other states, as far as I went, has this organization for this appeal, this format, different. The applicant gets to participate in arguments, but it doesn't get to participate in running the appeal. So what I'm trying to say is, you've provided uniquely to the city of Annapolis the ability for the applicant to participate at a different level than is the standard practice for everybody else in the state. And I objected to that early on. I submitted a motion that this be changed and the format be addressed. The city is the appellee. I'm the appellant. The applicant is a party to the discussion and questioning, cross-examination, but they're not a party to the briefs. And that, if you can go to all the other, I printed out all the rules for several other counties, and then I asked several lawyers, and this is the position. And while you're fixing the code standards, I'm suggesting that you fix the rules for the appeal board. I'm not criticizing you. This is the way it's been forever. I'm just saying it's not consistent, and the law, my little bit of knowledge about the law, is that you have to be consistent. This is not consistent with the rest of the state. It makes you an orphan. This is not orphan's court, but you are not in line with everybody else. District in Washington, D.C., it's got an administrative, this is not a variance. This is not a special exception. That's a whole different method. This is what Mr. Hyatt is used to.
We understand. Did you have another question? Gentlemen?
Mr. Chairman?
Mr. Yes,
Mr.
please.
I didn't mean for Steve to do all the talking, so I thought I'd interject here a little bit. To help bring this to fruition, can I have my neighbor step up and say a few words on my behalf on this whole issue?
Yeah, unfortunately, that's not part of the process. We don't have public testimony, and our rules do not permit a pro se party to be represented by someone who's not admitted.
Very good.
Sorry. I hope that rule will be changed, but that's what it is at the moment.
With regard to me, if I may address that, being admitted to the bar, or being an attorney, or just being a neighbor, can I represent Mr. Haney and address the board for a few minutes on his behalf in this matter?
If he wants you to represent him and you're admitted, you may represent him.
Yes, I would.
Well,
Any objection, Mr. Hyatt?
Yeah, I do object because this is a hearing on a motion. Mr. Henney hasn't participated in response to the motion, and now's not the time to have a argument on his behalf. I don't think he's entitled to do that. You know, we had Mr. Rogers supply you with his supplemental objection, and then someone else who drafted the points and authorities that, you know, his name was misspelled. He had a lot of misspellings in the first one, but his name was misspelled in the second one. Obviously, he didn't draft it.
All right,
and it's just not right.
Well, we'll hear from Mr. Haney's new counsel. I, for one, have very much appreciated his silent participation over the last 7 nights.
Thank you for the board, Heidi Halleck, on behalf of Mr. Cheney. Obviously, the memorandum of points and authorities was drafted by a counsel, and that would be me on this matter. And the issues that weren't addressed, and I think the board needs to understand, is clearly Mr. Hyatt has an argument that narrows the boards. He keeps saying over and over, and everybody says they stand in the shoes only of the Planning and Zoning Commissioner. But that's, in fact, not the case. There's nothing in the code that says it's strictly limited to just standing. And your questions were very clear as to what is the powers of the Planning and Zoning Director and what are the powers of the board. And on the first page of my memorandum of points and authorities, I noted that the board not only has the authority to determine various things, but it clearly states in the code, section 210840, that the board has the power to hear and decide appeals where it's alleged there's an error in an order, which is what we have here, a requirement, a decision or determination made by an administration official, or a body. So what you're doing here is not just standing in the feet and the shoes of the Planning and Zoning Director. You have overall, the board has powers to consider as to whether or not the administrative official made an error. That's what we have right in there in the code. And in this case, each of the department heads who are administrative officials who are to enforce the code, this board has authority over each of those department heads. And if the board here today determines that there are errors made by each of the department heads, you have the authority to overturn, you have the authority to address that error. And you have the authority to make decisions as you ought to do. And that's clearly presented. So your powers are not just limited to the powers of the Planning and Zoning Director. You, as a board, are given broader powers, much broader powers, to make a determination as to whether or not an administrative official or a body in the enforcement of this code made an error. And you did. You determined that each and every one of the department heads did not do what they were required to do. They didn't issue proper standards, and they didn't then make proper findings of fact as to whether or not their decisions were in accordance with those standards. And so this board is not just narrowly listed. The powers are not just the power of the Planning and Zoning Director. It is a broader power, clearly put in the code, to make decisions as it ought to, given an error made by administration officials or body. And so what this appeal is addressing is not just because and I think it goes right to the question here, whether or not the board, there was an error made, 2 and 2 equals 5. If there is an error by an administrative official, then you are here to correct it. And that's what the board does. And that's what you have done here, is you have said that there are standards, whether or not they were published, but you didn't, that the board, that these, each of the department heads did not apply the standards as necessary. And you found throughout that they erred in determining that they were adequate. And you used, and these standards were applied in all sorts of different ways. For example, in recreation, the board determined that you can't take private property, a restaurant, and the patio, and determine that it is public space. So you found an error, a clear error of violation of the published standards, and stated that that's inappropriate. And that is the board's purview in this. And it's clearly provided. For example, on the traffic issue, you were presented with some of these standards, and you determined that the tests were not done on the proper times of the day, the number of the hours, and that, for example, and it's clearly put in the standards, that the traffic study had to consider other factors, such as the closeness of an exit to an intersection. That's right there in the standards. And the board determined that the department head made an error, and by not considering the factors as necessarily put in the standards. There are clear standards that were violated by the department heads. And stormwater, for example, those standards that are published clearly state that at the outflow, if the outflow causes creek deterioration due to high exit volume of the outflow pipe, that it must not, that's one of the factors to be considered. And it was approved, the director of the department approved it in violation of what the standards were. So the board determined that there's a violation, and the board made those determinations clearly in its decision, and that in a unanimous decision. And so to say that the board has no authority, it only has such a super narrow authority, even if they made a mistake, 2 and 2 equals 100, the board has no authority, but the board does. The board has it right here, clearly in the code, in that section 210840, which outlines the board's powers. So you just can't keep it that narrow. And there is discretion of the board to make a determination not just of the planning and zoning director, but also as to administrative official errors. And that's where, and then the board did and used its discretion where it found what it had to do. And then the next question was, does the board have the authority to reverse or remand? And I addressed that issue. The board in code section 213020, the statute says clear that the Board of Appeals may affirm or reverse, wholly or in part, or it may modify the order or requirement or decision or determination as ought to be made, or the board may issue a new order, requirement, decision, and determination. And that's exactly what you did. So I think that the board is acting clearly within its enumerated powers, and that this argument that the board has such narrow powers it can't do it must not be the standard with this city. Because your job, it is specifically your job to enforce the code.
Okay. Thank you very much. All right.
Mr. Chairman, can I have a 1-minute rebuttal?
Mr. Hyatt.
Thank you.
After 8 nights, why not? Okay,
thank you. I think Ms. Halleck is spectacularly wrong. She refers to 2108-040. That's a general provision of the code. It spells out the decision-making bodies and officials. It talks about them generally. But what we are here for is an appeal of a decision of the planning and zoning director. That is spelled out under section 21.30.010. And the board has all the powers of the officer from whom the appeal is taken. That's when I talk about in the shoes of. That is what the code says. That is the appropriate code section. And I just want to say, when it talks about what the director shall do, this is new law for me, that shall doesn't mean mandatory. I would be stunned to see any Maryland case that says anything to the contrary. When a director of planning and zoning shall issue a certificate of adequacy, I think we all know what that means. And it's absurd to think that shall doesn't require a mandatory issuance of the certification. Thank you.
Thank you, Mr. Hyatt. All right, if my colleagues are ready, we'll try to decide what we want to do with this motion. We ready to do that? With your permission, I'll offer my suggestion. I am grateful to Mr. Hyatt for pointing out these web-published standards that were not referred to by anyone throughout 7 days of hearing, and for pointing out the reference in the code to the rate for calculating the fee in lieu. Those are things that obviously ought to be corrected. We owe that to any reviewing court to get that out of their way. So I think what I would recommend is that we grant the motion to the extent necessary to enter a revised order and a revised decision in order that corrects those things. Having said that, I don't think anything I've heard tonight changes the substance of what we've decided. The standards that have been discovered, many of them don't really add anything to what's in the statute. Some others do add standards. In the case of the police, an old standard that's clearly outdated and can't be applied. In the case of the stormwater standard for blown out streams, it clearly shows why the justification for what we did. So I think the appellants are absolutely right in their interpretation of the authority of the board. We certainly do have the power to remand and to issue the kind of order that we did. And we did that for good reasons. For one thing, the remand, I think, is the most expeditious solution from the point of view of the applicants. Maybe they don't think so. But it also gives our expert and well-meaning executive branch departments another chance to get it right. And it conserves the limited hearing resources of the board. Contrary to what Mr. Hyatt says, we have not ruled that the law should be different or better than what it is, but we've ruled that in certain instances, the departments have failed to implement the law as it is. The argument that we have no choice once the departments have certified to the Director of Planning and Zoning, I think is ludicrous. I understand it. But if you think about what it means, if that's true, the right of appeal is meaningless. Once the department heads tell the director, we approve, the director has to issue the certificate. And what remedy is there on an appeal? None. I don't think that was intended. I think that's ridiculous. I think Mr. Hyatt candidly has conceded that the director, when he gets the certifications from the departments, certainly has the ability to reject them where they're defective on their face. And in each of the 5 facilities that we've addressed, I think they were defective on their face. Some examples, the police department is using assumptions that are nowhere in the standards, and by the police department's own calculation, they failed to meet the standards unless you apply these other assumptions. Recreation, on its face, it says they're using spaces that we believe are not public spaces. And the same is true of the other. Tyler is failing, and there's nothing, the intersection's failing, and there's no requirement, condition to the approvals that be brought up to a passing grade, much less a statement of what a passing grade is. So that's where I am on this. As I said, my recommendation would be that we grant the motion to the extent necessary to revise the decision in order. That I'll be happy to do a revision and send it around for your approval if that's what we vote to do. And that once that decision has been signed, then the stay will be resolved and the matter can proceed. Discussion?
I think they're still on remand.
Mr. Chairman, just if you could clarify what you're proposing in terms of revising, so you would be in favor of reconsideration and then offering a revision to the previous decision?
Yeah,
the previous remand, excuse me.
Revisions would correct references to
the published standards.
Published standards and to the fee in lieu rate of calculation.
But in effect, it would be revision that would still remand those five sections back. It
wouldn't change
for further clarification or consideration by the department heads and
everything else
would
stay the same.
Well, let me think that through. If you think that is the best use of resources for the city and our own and in deference to the time constraints for a proposal that's been in front of the city for a long time.
Well, we could just deny, but that that leaves a lot more to argue about on appeal in our decision.
Right. As it relates to, I'll just reiterate where you went on that. I don't acknowledge the argument made by the applicant about the very cramped notion of what the board's powers are here. I cannot believe and would be terribly upset if I found out that the planning director, and I'm not saying he did, but if the planning director were to allow something that was obviously flawed on its face to go forward and being certified and into a process that ultimately would have been appealed at some point down the road. So I don't buy that argument at all. I also agree with you, and I think you can gain from my previous questions to Mr. Hyatt, that I just cannot believe that you can argue that on the one hand we have no discretion, and on the other hand we have the power to hear appeals on adequate public facilities. Mr. Rogers said at the close of his argument, have a look at the public facility, and I think that is a proper perspective to take a look at here. You're setting aside the idea that the applicant, that the applicant makes the argument that they have met the requirements of the code in proving adequacy. He can make that argument, that's fine, but I think largely I came away from the many hours of testimony and discussion not certain that those public facilities were adequate for the demands that this new project will have on it. It's not a cast aspersions to the project. It's to say that I just don't think in the end a proper full review came out the way I felt confident that those facilities were adequate under those circumstances. And that's really what the whole issue was about. And thus, in those 5 areas, particularly in the traffic study, in parks and recreation, using private space for public purposes, even the idea of how far the radius, the half-mile radius was being, if Parks and Recreation could go back and take a look at that and tell us, the map you were shown from other public testimony, and some of those other factors were erroneous, and this is the way we calculated this. I'm certainly open to hearing that, for sure, but I was very uncertain coming out of that section of the deliberations that was a proper consideration given in that particular area. As the traffic area, again, the comment you said a few moments ago resonates very clearly with me. It would be helpful for me to know why AD is not considered a failing intersection, or what those standards are. Having heard the testimony, I just felt that the scope of the study itself may not have been adequate to fully address not just the immediate impact area of upgrading the intersection at Tyler Avenue and Bay Ridge, but also, as is on the testimony and the record, Americana Drive, Monroe, Madison, all the way down Chesapeake to 6th Avenue, those intersections too, that I don't think they were given proper due. And as Dr. Chen and I both said during the hearings and on the night of our decision, I have serious concerns about, particularly in the Americana Drive area, how it's being utilized, how it was judged, its use now during construction and after construction is completed in terms of the postal facility, what its uses are there. I don't think there was adequate consideration given in the traffic study to that. So for those reasons, Mr. Chairman, I won't go into greater length on any of the other things, but suffice to say that I'm not terribly moved by anything I heard tonight to take me off the positions I took previously.
I mean, just for a point of clarification, it's the chair that makes the determination on motions, correct? So,
not on this motion. We vote.
Okay. I'm not going to go to the sum and substance of what we discussed last time. I don't think there was anything that really moved me one way or the other off of what we previously decided. My issue, as you guys can probably tell from this evening, was whether we actually have the authority to do that. I find Mr. Hyatt's arguments succinct to the point, but I don't necessarily think I can follow them all the way through to the end that he wants us to reach. And the good news is I'm sure we'll find out from a higher authority as to what the powers of this board actually are. I think there's conflict between the sections cited by the appellant and of the applicant, and as much as I guess we'll find out. It seems illogical to me that the director of the planning and zoning has no power whatsoever. If they can make the determination on a glaring error if 2 + 2 is 5, that's not in the code, it's shall. So I'm not sure how we get from 2 + 2 is 5 can be revised to the flawed methodology behind it. I think that the code, we're stuck with it as it is, but it's not properly drafted. I don't think it gives us much help, but I would find it difficult that the director of planning and zoning, and therefore us, has no ability to check what is done by the individual department heads to determine adequate public facilities.
Yeah, the appeal right means nothing.
Right. Then if that were the case, then I'm very sad that we wasted 7 nights of our life, because the testimony all would have needed to be was, here's the certificate, here's the certificate, here's the certificate, here's the certificate, and we're done. I mean, that would have taken 20 minutes, and we never would have had anything on the sum and substance of what they actually did to determine that. So to me, I hear what Mr. Hyatt's saying. It's certainly, I can see it in the code. I hear the argument, but I just can't believe that would be actually what the role, and maybe I'm interjecting when I shouldn't, and I should just be going by the language itself, but I think there are other parts of the code, as pointed out, I think it's, I'm not going to quote it off. I would go back and look, but I think there are other parts of the code that may allow us to have that discretionary authority to go back and look at the methodology that was used to make a de novo determination as to whether or not there was adequate public facilities.
Mr. Chairman, I'm very grateful to all the parties, including the board's counsel, for their legal opinions on this matter. I think for my part, after 8 days, was it, of evidence that I considered everything carefully, the facts that were presented, the evidence that was presented. If indeed the applicant truly believed that this board did not have the power to even hear the appeal, I'm not sure why the applicant didn't make that argument at the time.
Oh, I think he did.
Oh, did he? Yeah. Okay, I didn't pick up on it. Maybe because
subtle.
it made no sense to me. But I do, at the end of the day, Mr. Chairman, interpret 4-306 broadly. I do believe that this board does have powers of discretion, and I do believe that the opinion we rendered was correct, and that we have had and have the ability to make that decision.
Okay,
Oh, and also, I would say that the standards that were found by Mr. Hyatt do not change my view of the evidence.
So, suggestions on how to proceed? I mean, it seems there's a pretty clear consensus not to change the substance of what we've done. But do you guys share my concern for cleaning up the decision for the reviewing court?
Yes, I'm fine with that.
I agree.
You good with that?
Yes.
So would someone like to make a motion?
I move that the previous decision to remand the appeal, I've got it right here in front of me. What? To reconsider? Mr. Chairman, I move that we reconsider the previous decision to remand on SDP 2018-006.
And to
The appeal 2018-002.
and to provide a revised decision correcting references.
And to provide a revised decision for correcting
references to published standards.
References to published standards.
Fee in lieu calculation.
and recalculations.
Second,
I second the motion.
all in favor?
Aye.
Aye.
Thank you all very much. Why don't we take a 5-minute break, and then we'll take up the special exception. Oh, if you want to send me something. I'll do a little introductory paragraph. So when we come back, make another motion to deny the.
But I think we need to clarify which motion we're granting.
Yeah.
So you move to grant the motion.
We should probably, before we take a break, redo it, because they're all going to leave.
All right. We neglected to deal with part of Mr. Rogers' counter motion, so we'll deal with that now before we actually recess. Okay, so Mr. Walsh, your motion related to the motion to Mr. Hyatt's motion Now, do we have a motion with respect to Mr. Rogers' counter motion to find the 4 remaining facilities inadequate?
Yeah, I move that, that the board not reconsider that motion in those 4 areas. I move to deny reconsideration.
Second?
Aye.
All in favor? Yeah.
Second.
All in favor?
Aye.
Aye. Thank you. Now we're recessed.
So I need to. Okay, so his first one was so sick.
Oh, yeah. They send me something like, hey, can we have some money? I'm like, sure, how much can I give you? Remember when I read this? Just like everyone else, don't ask.
Exactly.
That was one of the things that truly baffled me.
It's insane. It's so stupid.
You get a point now for face the next election, and so it could be anywhere between 2 months.
Pretty much.
And nobody knows.
Right, and I don't know which way is better, whether, because if it's 3.5 years to the next election, now you shut down, presumably you gotta wait, so you shut that down for 3.5 years, and then you lose, and then what do? I guess it's better to do it right before the election, because then.
Thomas. And Donovan, do you know Donovan Harold? He's in public works.
It's just, to me, it's just, I've never.
It's such a conflict.
It is.
It's a waste of your time. They're out on nights and weekends, pound in the paper, you ask residents. It's not getting money from Joe Schmo off the street. They're always getting it from attorneys. Right. And they're between Prince George's County and Arundel County. I think there's 10 judges.
That's what we're trying to get done, right?
So we're
Granted, it goes into
meeting
the
with all the
general,
department directors.
they run the slate, but still, it's like.
We've met with Public Works and Transportation. And on Thursday, we're meeting with Police, Fire, and Rec Department.
I'll find out. So the same slate
Going
shows up
over
on
the
both.
template with them. They have to get us any changes to it.
Yes. Yeah, and it's just alphabetical. It doesn't,
I'm hoping
And if somebody wants to take you
getting
on,
March.
they want to-
I'm aiming.
well, not everyone on the, it's not. So the slate is sort of made up. They're just, that's their way of marketing. Yeah. So it's not like if one on the slate doesn't get it, the whole slate doesn't get it. It's just literally.
No, I knew that.
Yeah,
Whoever it is, it's both, but.
Well, my wife,
We're doing it.
she for Judge Kiesling, who's now Judge Ripley, and it was, she was her first clerk, so we had to deal with the judicial election process, and she won, and her running mate lost.
Did they issue a written appeal for the hearing tonight?
Okay, Ben's on the job now.
How long have you been practicing? How many? 2 years. So yeah. You gotta have somebody to cover it. Well, this next one should be very short and sweet.
What is the special exception for?
That building right across the street.
And are they asking for like a setback of some sort? It's
No, I think
meeting and.
I think just government use. Tom will tell us shortly. All right, should we try to get out of here by 9:30? All right, now we'll return to special exception application 2020-001. We've substituted board counsel. Mr. Ben Henry will be counsel to the board for this matter. Thanks very much to Chris Beard for his help with the last one. Will everyone and anyone who intends to testify on special exception 20-01 please stand for the oath? Please raise your right hand, sir. Do you swear or affirm, subject to penalties for perjury, that the evidence you will give tonight will be true to the best of your knowledge? Thank you. All right, Mr. Smith, are you going to introduce the application for us?
I am, Mr. Chairman. I'm going to be substituting for Ms. Rouse this evening.
That'll be a hard thing to do.
I'll pass that on to her tomorrow. So for the record, my name is Thomas Smith, and I'm the Chief of Current Planning for the City of Annapolis. And this is a special supplement request for a government-related use in application SE 2020-001. Both the applicant and the owner of the property are the City of Annapolis in this case. The location is 163 Duke of Gloucester Street, which is literally across the street from us this evening. The property is known as the Maynard Burgess House. It's zoned C1A, which is the Special Conservation Residence District. It is also in the IDA critical area. I believe there are two members of the board, though Mr. Zazali is not here this evening, that were present when the same special exception application was reviewed and approved in 2013. So, Mr. Chairman, I think you're the lone memory on from that. I think that opinion was from 2013 was included in your application for Ms. Rouse. So the property remains vacant. It's a two-story historic structure with significant African-American really historical resources and significance that the city, at least in 2013, had entered into a capital improvement project to improve the property, both interior and exterior, but ran out of funding to complete that project. And really, since 2013, nothing has changed. The property remains vacant. The adjacent land uses remain the same as far as governmental offices, churches, and residents in the vicinity. In 2018, the city submitted a new application, a grant funding from the African American Heritage Preservation Grant Program, which encourages the identification and preservation of building sites, communities of historical and cultural importance of the African American experiences in the state of Maryland. As I mentioned previously, the uses surrounding this property have not changed. They are church-related uses, governmental office uses, some retail, residential, in a variety up and down the street on both sides. Hence, the adjacent properties are all fully developed. The proposed use would therefore not really impede any normal and orderly development or the improvements to those surrounding properties, or really have any detrimental effect to the public health, safety, morals, and convenience and general welfare or market value to their surrounding properties. There are adequate facilities, including streets, ingress, egress, drainage, water, sewer, police, and fire protection readily available. Through the course of the departmental's review, public notice was posted as requirements and met, as well as an interdepartmental agency review. Planning and Zoning found the application that is consistent with the purposes of the C1A zoning district, the critical area requirements, the 2009 comprehensive plan, and all the special exception review criteria. In particular to the comprehensive plan, staff notes the principles and objectives for the land use and economic development section encourage, and I'm not sure if I'm quoting this word for word, but the redevelopment of existing properties and respect for historic preservation. So really, including the improvement of vacant and underutilized parcels that are to strengthen the neighborhood and community character and retain historic and cultural quality to downtown Annapolis. We certainly think this property being converted to government-related uses and exhibit space meets that objective. In the interagency review process, Ms. Rao sent the application to Fire, Police, Public Works, Transportation, and none of those reviewing agencies had any objections to the project. Public comment was sent to the alderwoman, who was here this evening for Ward 1 and Ward 1 Residents Associations, and both provided comments in support of this project. With that, staff in the report on pages 7 and 8 recommended approval of the 8 conditions that are noted. Of those, specifically condition 1, which refers to the plans that were submitted condition 2, that prior to any issuance of permits, that plats or easements or any agreements be recorded in the land record. And condition 3, prior to issuance of permits, that the project obtain Historic Preservation Commission approval. And I believe Public Works is here to represent the city as applicant.
That is correct.
That's all I have.
Donovan Harrell, City of Annapolis Public Works. And reiterating what Mr. Smith said, we brought this project before the Board of Appeals in 2013. Project design basically hasn't changed. We have updated some of the building codes. That's what the redesign basically addressed. The building footprints still remains the same. And basically, we're trying to finish what we started in 2013. In 2013, we brought this project to you to rehabilitate the entire facility. Because of lack of funding, we were only able to take care of the outside of the building, exterior, removing all of the historic siding and replacing the historic siding, along with providing a weatherproof barrier underneath the siding and in between the plywood. This time around, we want to go ahead and take care of the interior of the facility. And it's important for the city of Annapolis because it focuses on the Maynard Burgess families. They were free black families who owned the house. And along with providing office space for the city, it'd be an interpretation space in the facility also, which would also detail the lives of those families and also the lives of African Americans, any artifacts that we could place into the facility for African Americans in the city of Annapolis. No other homestead in the city of Annapolis provides that for African Americans in the city of Annapolis. And as the property is inaccessible right now, the public is largely unaware of its history and significance and unable to understand its value as both present and future resource. So if we were able to complete this project, I think that would be a valuable resource for the city. And I believe we meet all the criteria to provide for a special exception. And I hope if you guys have read the packet that was given out to the board, that you'll agree that this would be a project that is worth undertaking.
Thank you. Thank you for your concise, illuminating presentation, Mr. Harrell. Any questions for Mr. Harrell?
No, we appreciate brevity.
Right. All right. Public comments? Comments from our Ward 1 alderwoman? Anything to say, Ellie? Okay. Great. Sounds good to me. Okay. Well, if there's no more testimony on that, we'll close the record and get to deliberations momentarily. Tammy, do we have any minutes we need to approve?
We do have January 7th, but there's no printed copy.
Okay, so we'll do that the next time.
Okay.
All right. Any discussion on special exception 2001?
No.
Anyone like to make a motion?
Mr. Chairman, I move that that a special exception for 2020-001 be approved, that based on the evidence presented here tonight, at the city's recommendations, because the application is consistent with and compliant with the city and state plans and with the comprehensive plan of the city of Annapolis, that it comports with, in compliance with the special exception standards based on the evidence presented here tonight, upon the evidence that, and the record here, along with the staff recommendations that are outlined in the staff report, the 9 staff recommendations, they're misnumbered, by the way. 4 is numbered twice. So I'm assuming that's 9, Tom? Yes. Under staff recommendations on page 7.
Good catch, Mr. Walsh. Yes, there is a typo.
So based on those 9 staff recommendations and what I've said previously, I move that the special exception be approved.
Second.
All in favor?
Aye.
Congratulations, sir. We're happy to approve your application.
Thank you.
Looking forward to seeing it open.
That's great,
When
yeah.
will it be open?
We hope sometime at the in fall of this year.
Wonderful.
Great.
That's such a great thing.
Terrific. All right. I don't think we have any opinions to sign tonight.
Russ. Thank you.
Motion to adjourn?
Yes. Motion to adjourn, second. All in favor?
Aye.
I'll, give me a week or so and I'll circulate a draft of that.